what the type of dispute it is, and on how to go about with it. So first thing what a council considers is the client's requirement of confidentiality, especially when it's a startup. It's a startup, or it's some kind of chain of some kind of a chain of company or something like that. What happens is the council generally asks the business person, asks their client as to what they want. So usually what happens is they need confidentiality, and they want to get over with the issue as soon as possible. See, what happens is businesses and businessmen are fast paced people, because it is a competitive world, and it's a very big rat race when it comes to businesses. So what happens is the businessman wants to be on par with someone else. Otherwise, he knows he will be left behind. So in order not to be left behind, what happens is the businessman or the entrepreneur, they want to finish it off as soon as possible. And see, that is where the council will sit and consider what method of dispute resolution to choose. And one thing, and what happens is the the council in this case needs to think about how quickly it has to resolve. So the best thing is to check out all the to sit and check with the party as to what he wants and how amicably he or she wants to settle the dispute, and accordingly suggest. See, if it is of criminal nature, then it's a different story. But when it comes to a civil or a commercial matter, definitely it is the onus of the what do you call, the council. It is to suggest a proper method. And sometimes what happens is the clueless person, who the clueless client, he doesn't understand, and they just want to go about with it as soon as possible, or sometimes they don't even respond to the issue, and it takes time for them. So these are certain challenges where the council has to sit and explain it to the client as to as to how to go for it. See, sometimes what happens is, one more thing is, the business person, the client who is an entrepreneur, he or she feels that it is a lot of burden, it is a lot of cost for him or her to invoke ADR or to invoke ADR, and they think that court fees is much less, and they think they can go for litigation. But and it is at that time, and but they also want to get it over. They also want to get over with the dispute very fast. So it is the onus of the council to sit and explain all the pros and cons patiently. And as a council, sometimes this is something very challenging, especially when the entrepreneur who is the client is a novice in business. So this is my take on your question.
Thank you, ma'am. And another thing I want to ask, in your experience, what has been the primary factor that drives your choice between litigation and ADR for resolving disputes?
Okay, excellent question. Firstly, litigation and ADR are like both my eyes. For any dispute resolution professional, be it ADR or litigation, it is like both the eyes, and we can't choose between one, because they are dependent on one another because of the enactments that we have. Uh, See, but I would definitely, if there is something where I have to choose something, if I have to choose a dispute resolution mechanism for my client, definitely I would suggest mediation first. And see, as I already mentioned previously, time is money for running a business. And in this competitive world, every client, every entrepreneur wants to get over with this dispute, or wants to get over with this problem, and wants to move on. And especially today's generation businessmen, startup owners, or those who have started new businesses, they literally want immediate results. They just want to just finish it off, do whatever it takes, and then they just want to move on with their business. uh, so I, as a practitioner, I would definitely choose, if asked to choose for ADR or litigation, I would definitely prefer a combination method of dispute resolution, where litigation is always a backup plan. It is a plan B basically. But apart from that, I have definitely suggested many of my clients to go for a combination of dispute resolution, and this again based on their dispute resolution clauses that they have. I have made certain suggestions, and now because we have many enactments coming up, many enactments that have already been there. So what we do is we generally suggest the client to start with mediation, because not everybody can afford much. That is one thing. So, I mean, I'm talking about the medium or small scale businesses where they can't afford to go for AD arbitration proceedings, or they cannot go to a tribunal initially. So, we definitely suggest them to go for mediation, which is cost effective, which is also quick in resolving the disputes. So, again, I would like to say that yet again, with all due respects, I am also a litigation practitioner. So I would vouch for a person or a business to definitely go for ADR, but not without litigation, because if nothing of this works, definitely litigation is there. It is like, your plan B. So that's like a backbone of everything. So even when you're passing an arbitration award, you go there for an enactment, for an enforcement. Now, after the mediation settlement is there, again you have to go to the court for enforcement of the same. So litigation is always there, no matter what. So it's like both the eyes.
Thank you, ma'am. Ma'am, which aspect of ADR do you believe businesses benefit from? Like the most cost saving, confidentiality, or speed, like things?
Okay. No, this is yet again a beautiful question. So there is nothing like a best method of ADR, but I would definitely suggest mediation. See, as I already mentioned, you can go for a combination of ADR methods. You can invoke a combination like MED-ARB, ARB, MED-ARB, or MED-ARB, MED. You can choose that one. But the best method for confidentiality, for saving the cost and speed, definitely mediation is the best. See, usually what happens in commercial disputes or corporate disputes is that they just want to finish it off, because they're running like crazy. So at that point of time, I would definitely suggest to go for mediation, where or even see, sometimes you can even if the dispute is not completely over, it is just in the nascent stage, where there is just a small conflict, I would also advise the parties to go for negotiation.
Oh, ma'am, have you encountered a situation where a delay in coming up with a resolution, you have to invoke ADR? What was your experience like? Can I know?
Say definitely. I have had quite some experience where we had to invoke Section 89 of CPC during the course of a litigation. And this was, I think, a year ago or something, where one of my client was facing a lot of trouble, because they just wanted to finish it, and confidentiality mattered a lot for them, because they were planning to go for they were planning to go public with their company. So at that point of time, what we had to do was, if it is in litigation, then things come out easily. The name will be affected. They will not have investors in future. So in order to avoid that, we and the other party also, the opposite party also was willing to settle the dispute wisely, and as much as possible they wanted to have a future relation with each other. So at that point of time, we did invoke Section 89 of CPC, and we went for mediation, and we it was resolved within 8 months. Something which was expected to complete within 3 or 4 years time was resolved within 8 months, and now they are, they've joined hands for future projects as well.
Ma'am, nowadays we are seeing that disputes are going on between companies. So, what is the right time when to invoke mediation clause if there are disputes arising between companies?
Mm-hmm. Okay. See, technically and legally also, you can invoke mediation anytime during the course of anytime during the course of litigation. There is no such mandate where you have to invoke it at this time or that time. And thankfully, there are many enactments, such as, there are many enactments which encourage the parties to invoke mediation to settle the dispute. So there is no right time as such, but no time specified by law. But as per Commercial Courts Act, it mandates, it is, although this thing is a debatable provision, but it mandates the parties to go for mediation before starting the litigation. It's called as a pre-lit mediation provision. So the I think the reason why this provision was mentioned, this provision was there, this provision has been added into this Commercial Courts Act, is because before even wasting the court's time, before even dragging the whole dispute, it's better to resolve it through mediation, is what I think is the intention of inserting this provision in the enactment. But again, it's, mediation is a voluntary process. So what happens is the voluntariness of mediation is questioned in this. So this is a debatable one. But there is, as such, as per see, when there is some kind of civil litigation going on, when there is some consumer dispute is going on, or maybe a company law related dispute is going on, that at any stage of the dispute, any stage of the litigation, you can invoke mediation. And one more thing, maybe, like for the previous question, I'm giving an answer again. Thing is, maybe when the parties want to settle the dispute amicably, and they are wise enough to say that I don't want to fight anymore, I don't want to litigate anymore, and I am also, my cost is also being affected, your cost is also being affected, why not we come to a compromise and settle it? So at that point of time, where both minds are meeting and they want to settle it, so they definitely, you can invoke mediation and settle it off then and there. So there is no right time as such. Every time is a right time to invoke mediation. And it's definitely, you all know the advantages of mediation. I don't have to repeat it again. Yeah.
Thanks for throwing light on our questions, ma'am. Now, Manushi ma'am will take over from here. Thank you once again.
You're welcome. Manushi, your mic is off. Please switch it on.
Yeah.
Yes.
Is it audible now, ma'am?
Yes.
Yeah. So, ma'am, what key changes could make ADR more appealing for businesses compared to traditional litigation? I mean, the reason for asking this question is, how do we, educate the businesses so that, they opt for ADR rather than going to the court?
Can you please repeat the question again?
So what are the key changes that we can make in ADR, or we can educate the businesses that they have an option of opting for arbitration and mediation when compared to the traditional litigation? Because when it comes to these business owners and other CEOs, not everybody is aware about that they have something called as arbitration or mediation. So how do we make them aware of this arbitration and mediation? Is what are the key changes we have to make so that we can make them aware, or what are the steps we have to take?
Right. First thing, with all due respects, again, I would definitely suggest the in-house counsels to throw some light on ADR to while drafting their agreements, and even before drafting the agreements, I would definitely suggest the in-house counsels and the retainers or the practicing advocates who are representing the companies, the councils, to educate and create awareness about ADR methods, especially about arbitration and mediation to the companies. Because see, as per there have been several incidences of mine where I had to sit and educate my clients for hours together. And see, litigation, end of the day, it's going to make you run around. And as people say, you have this तारीख पे तारीख thing going, and सबके चप्पल तो घिस जाते हैं litigation में. मेरा खुद का चप्पल घिसा being a counsel. So that is the only disadvantage of litigation. And see, one more thing, they should be explained about one particular concept, where people think that ADR, especially arbitration, is uh, it's very hard on their pocket. It's very tough. They think that it is very tough on their pocket. But let me tell you one thing. You see the cost involved for a litigation that is going for 10 years, and you are paying, and the business owner or the entrepreneur, he is paying a lot of money for his litigation, okay, be it counsel's costs or miscellaneous costs or their travel, whatever is involved, minus the court fee. It's going to be a very hefty sum, end of the day. But when you're invoking arbitration, as per the act, it is going to get over within 1 year, or let's say 1 year, 3 months, not more than that, okay? And the cost involved, they think they are looking at the lump sum, but they're not thinking about the bigger amount that they've been giving in past. So this thing has to be explained clearly to the entrepreneurs through maybe the councils or their retainers or their in-house counsel, or whoever is taking, or whoever is in the advisory capacity. So this thing is something that is going to bring about a change in ADR, in invoking ADR mechanisms. Now, second one is encouraging students. I've been seeing a lot of students showing interest now, but they are only thinking from the commercial angle, from the point of making money. But let me tell you, it's not just money. You are definitely going to be a dispute analyst, where you will know how important litigation is, how important arbitration is, and how important mediation is, as and when you keep on invoking it, as and when you're taking that case, you will be knowing. So first thing I would say is that in college levels, definitely students have to be encouraged to resolve their disputes through, maybe set up a small committee, not just ADR, but separate committees again within that for arbitration and mediation, so that everything starts from the student. And I'm glad that there are many firms like Dispute Resolution Hub, or many colleges which are encouraging the students in taking up in participating in arbitration and mediation competitions. And not just that, I feel that they have to be educated completely about ADR. I think that is somewhere where students are lacking about it. And I do not suggest them to be certified immediately during their college. I mean, if they have that talent, and if they are really focused enough, yes, let them take it up, let them get certified. But before that, education of ADR has to be proper. It should not just be a mere clinical course where they are just writing, they're just writing their writing answers for the simulations and giving the records. This is not the thing. There should be some kind of some kind of a session where students are encouraged. Some kind of simulation has to be given, and the students are supposed to be, and the students can enact. Apart from that, we should also encourage councils to to invoke arbitrations as per Indian laws, and not go somewhere to Singapore or London just for the sake of going. They should keep enforcement in mind. They should think about all that, because no act is going to change. Act might change. We're getting a lot of inputs on it. So definitely, they have to invoke arbitration in India. We're going to have a lot of institutions coming up. So it is always better to invoke arbitration or mediation in India itself through institutions.
But ma'am, now if anybody talks about invoking arbitration, the first name which comes to the mind of anybody is SIAC, which is the Singapore International Arbitration Center. So how do we make India as an international hub, so that people opt India as a seat for resolving the disputes?
See, not just SIAC, you have ICC, you have so many
Correct.
other.
There are others. Yeah, but the preferred seat of arbitration when it comes to, resolving cross-border disputes or any international dispute, the first name which comes to the mind of any business owner or any entrepreneur is SIAC. So how do we make India as the international hub, so that people opt India as a seat for the resolving the disputes?
Yes, see, currently enforcement of foreign awards is a challenge as per our acts. But and it is quite easier in Singapore. And people over here are not really aware of certain loopholes also in the law. So that is the reason why they think, and there are some, and one more thing, there are some people who think Singapore is a cool place, I can get to travel, so I will invoke arbitration there. That shouldn't be the thing. So thing is, there has to be some changes as to enforcement of the foreign awards basically. Apart from that, see, we have courts which are our courts are actually quite flexible, and the judiciary is actually supporting people to take up arbitrations. But thing is, we should have proper we should create proper awareness. There are so many there are so many arbitration and mediation centers in India, but they are all sleeping. Maybe they're taking up few domestic cases, and that's it. See, it is up to the centers to encourage people, to encourage getting more cases into them. And see, SIAC, I think they conduct a lot of events and industry specific events. So if those kind of events are happening in India, and one more thing, we should have certain chambers of commerce who have to be supported. Certain business associations have to support this. That is when India can be a hub for arbitration or mediation. If the businesses do not support, this cannot happen.
Very true, ma'am. So now, as we have seen, there are few recent amendments which are being made in the arbitration bill, and new sections are being proposed, and certain sections are being amended, and few sections are being inserted into the same. So, what are your views on the section 9A, which is relating to the emergency arbitration, which is being inserted in the new recent arbitration bill?
Okay. See, one thing. Reason why emergency arbitrators are asked to. I mean, why arbitrators?
Before that, one was sorry to interrupt you, ma'am. If you can explain why emergency arbitration is required, would be good.
Okay. See, one thing. Section 9A, it speaks about appointment of emergency arbitrators. Okay. Not emergency arbitration as such. Section 9. So emergency arbitrators are appointed at certain situations where the existing arbitrator, there could be an issue as to their disclosure or their bias or various reasons, or maybe the arbitrator has fallen sick and is not in a position to continue with the tribunal. So at that point of time, we need an emergency arbitrator in order to go ahead, in order to progress with the arbitration proceeding. So that is the reason why there is a section 9A that has been proposed in the act. Because thing is, what happens is sometimes there have been certain situations in the past, or even now it is happening, where sometimes even the arbitrators have passed away, they have expired, especially during COVID times. There have been certain situations where many professional arbitrators, they passed away, or they were stuck with serious illness. So at that point of time, we need an emergency arbitrator who has to who helps the tribunal in taking the process forward. So I think Section 9A is one of the best insertion into the proposed bill, which speaks about the arbitral institutions who may, for the purpose of grant of certain interim measures, which is referred in Section 9. And to provide for appointment of emergency arbitrators, before the constitution of the tribunal. So we will have a backup. Basically, they have a backup of an arbitrator, and this is actually a very good one. And one more thing, here in this section 9A, clause number 4, subclause 4, it says that an order of the emergency arbitrator may be confirmed, modified, or vacated in whole or in part by an order or arbitral tribunal made by the tribunal. So, emergency arbitrator, the order passed by the order or award passed by an emergency arbitrator, it can be modified or vacated by the other members of the tribunal. So that is one good advantage of inserting Section 9A.
Thank you so much, ma'am. And moving on there is another new section which is being introduced in the bill, which is the new arbitration amendment bill, which is section 34A, which talks about establishing an appellant arbitral tribunal. So, what are your views on this? Of this, is it required to that whatever arbitral awards which are passed by the arbitral tribunal, is there really a need that there is an appellant arbitral tribunal required at this point in time?
See, instead of that, there is a I think there is a provision where instead of setting aside the court itself, when the arbitral award is going for enforcement, it's better that the enactment allows the court to verify with the arbitrator, to interact with the arbitrator, and pass a proper and maybe make some modifications or changes to the arbitration award, and everybody gets an opportunity to question, to challenge the award as such. But appellate arbitral tribunal, I don't think it will work out, because again it is going to be like any other court proceeding. I don't think there will be any difference between a court and an arbitration procedure and an arbitration, basically. So it's just like a court procedure where you are going for appeal and then you have another appeal. So I don't think see, there have been many tribunals which were formed thinking that they will resolve it without the help of CPC, and there are many statutory bodies. But again, they have an appellate board. Again, that appellate will go to Supreme Court. I mean, that's not required. Then where is the core and where is the essence of arbitration? It's killing this appellate tribunal. Is, with all due respects, it is killing the essence of arbitration. But maybe if we are seeing it on a positive note, maybe someone can challenge it. Maybe someone can challenge it, and let the challenge be to the same arbitrators itself. Where they have an opportunity, where the tribunal has an opportunity to discuss the award, whether it is going, whether the award passed is biased, or I cannot use biased, whether the award passed is not in consistence with the public policy or something like that, where both the parties are somewhere the other being affected. So let there be discussions instead of having this appellate body, because it's totally going to kill the essence of arbitration, is what I feel. I mean, this is purely my opinion. It may differ from one person to another.
Yeah. Yes, because ma'am, the business or any entrepreneur, they are opting for arbitration and mediation because it is we who are educating them that you do not need to visit the court. Now, if the appellant arbitral tribunal comes into picture, then how do they believe us in what we are trying to explaining to them, or giving them the benefits of ADR activities? It will be the same, that they will be again going to the court proceedings, which they do not want. That is the reason they are opting it for ADR is nothing but something like a out of the court settlement in a faster way.
See, yeah, exactly. See, one more thing. Okay, I now this gave me another idea. See, maybe if the parties are going for an institutional arbitration, at that time there can be some other arbitrators. They can appeal in the same institution itself. Yet again with the same set of arbitrators for while challenging the award or questioning the award. I think that will make some sense, but again, not to have a separate body for that somewhere else, and that's going to be tiring to the parties. It's literally going to, it's going to be another private court. As of now, also arbitrations are being run as private courts only. Now, this will add more value to that privatization.
Very true, ma'am. Now, one more section which is being inserted in the new arbitration amendment bill is section 43K, which talks about, ma'am, recognition of arbitral institutions. And do you really think that it is the right time to insert this section, and it is the need of the hour for the recognition of arbitral institutions?
Very much. Very much, yes. I do support this section because as of now, most of the Indians who are invoking arbitrations, they're going for ad hoc. And there are a lot of confusions and discrepancies happening in the name of arbitration. See, recently there was a judgment on there was a recent case, I think yesterday or day before yesterday, where a person posed as an arbitrator recognized by the government and he ran his own court. This happened
In
recently.
Gujarat. In Gujarat.
Yes. Yes. So, we have to, now is the right time to recognize arbitration institutions because, it's going to pave way for a greater future is what I feel. Uh, and instead of going for ad hoc arbitrations, because in ad hoc arbitrations, uh, I personally have dealt with many cases where there have been unilateral appointments of arbitrators. I mean, unilateral in the sense appointment of arbitrator is only through one party and the other party doesn't know. There is a lot of issues as to case management, or towards having a tribunal secretary. So why not we make it into a proper institution where everything is taken care of and there is no much tension as to going ahead with the procedure. So this is the right time to recognize, to insert this particular provision 43K into the act, wherein this will encourage a lot of institutions encourage a lot of people to take up arbitrations, to resort to arbitration instead of going to the courts or have a lengthy procedure. So I think this is actually the right time. See, now if we are starting 10 years down the line or 5 years down the line, we will be the hub of arbitration or mediation in India. That is going to be for sure. You have to, I think you have to switch on your mic.
Your mic is mute.
Yeah. One question on mediation. How can mediation be effectively integrated into a company's dispute resolution strategy to minimize business interruptions? Hello.
See, mediation. Yeah, I can. Yeah, I can listen to you. You're audible.
Yeah.
See, one thing is through drafting the dispute resolution clause. What people generally do is they don't draft the clause properly. And see, before drafting, there are a few steps to be followed where you have to sit with the client and discuss the same thing with both the parties, let them have negotiations over the contract clauses, and then draft a proper dispute resolution clause where you are clearly specifying. But at certain times where none of this is working out, or where the dispute resolution clause is it's very old, at that point of time, what you can do is mediation can be invoked. You can you can ask the parties, sit with them, explain about mediation, and immediately go with it. Because see, mediation ensures you a lot of confidentiality, and it also ensures it ensures speedy resolution for your disputes. So at any point of time they can invoke mediation, and best thing is through a clause, through drafting a clause. See, now institutes are also, there are institutions not just for arbitrations but also for mediations. So I think the dispute resolution hub also has mediation rooms, right?
Yes, ma'am.
So it is owners of the institution also to to conduct events, to talk to discuss this with many chambers of commerce and tell them that mediation is there. So that's how you can invoke it at any point of time.
So, ma'am, like you mentioned in the like we were talking previously, it is becoming difficult for enforcing the arbitration or mediation awards. So, what are the steps we can take so that we can see that these awards are being enforced properly? So, awards are being passed, but they are not being enforced.
See, as of now, enforcement is through courts only. Or before enforcement, if the party is willing to settle, they'll tell that okay, chalo arbitration ka award aa gaya, so we will settle it off. or maybe, you know, they will, if that is not successful, they will go for a combination of ARB med or something like that, and then, you know, they'll go. But for
So,
enforcement, I think
in
I
what
think
situations do they opt for, first arbitration, then it goes to mediation, then again it comes to arbitration, or mediation, arbitration, mediation? How is this procedure?
see,
So if a
as
party is
you
opting for mediation, but
see, it's like there are two kids who are fighting for a chocolate. Okay. Now, the kid's mother comes in between, kid's mom or dad or some third party grandmother or grandfather, whoever it is, they come in between, sit as mediator, and they tell, आधा आधा ले लो दोनों को, तुम्हारा भी मिल गया, तुम्हारा भी तुमको भी मिलेगा. And this kid says, no, no, I don't want to go for it. I want the whole chocolate. Now, what happens is here conflict has arisen here. Now they go to an arbitrator and state all the technical facts, all evidence and everything. They'll tell, no, no, I got it at this time. I got 10 marks more than this kid, and that is why I require it. Now, mediation was unsuccessful previously. Now they go for arbitration. They're giving all the facts. Now again, you know, the other kid says, no, no, he's challenging this kid's evidence is, and then he's telling, no, no, I deserve it because I'm getting less marks. So you know, this is to cheer me and all that. So now this is also unsuccessful. Now again, they will tell, no, no, chalo, no, I also want to have this chocolate. This kid says, okay, I also want. Now, be it 70% I will take or 30% you will take, जो भी है. चलो, they both are wise enough, chocolate भी पिघल रहा है, चलो दोनों settlement पे आ जाएंगे, they are wise enough now. Third time again they are invoking mediation. Now they will call the grandmother will come, cut it into half and give it to them. Half or 70-30 or 60-40, whatever combination they want, they will give. And maybe they'll collaborate hereafter and tell that, no, no, I will next time when I get, I will also give it to you. Now here a business relation is also made between both of them. So this is just an example I'm giving from a home scenario, but in businesses also, in any situation where a conflict arises, it depends on the party. See, initially when they invoke mediation, they think, okay, chalo, I will resolve. But it depends on their counsels. It depends on their at that point of time what they are undergoing, and they might not enter. They might not come for a settlement. Then they will tell, we will go for arbitration. No, they feel arbitration is also taxing. So they'll tell, no, no, we will, arbitration is not working out. Let us go for mediation. Sometimes if none of this is working out, they will tell, no, no, chalo, nothing is working out. I will go to the court. I will go for litigation. So it depends on the parties. It's like there is no right time to invoke. But arbitration, again, I'm telling you, for contractual issues where even mediation cannot work and it is too technical in nature, where some where there has been a lot of loss to one party, then definitely they have to go for arbitration as per the law, or at least go for ad hoc, or approach some institute and you take it up, or approach the court and file a section 89, get an arbitration, or file a this is section 11 petition to the court and get an arbitrator appointed. So these are certain situations where, you know, where one person has faced a lot of loss, and the other party may or may not be responsible for it, but they want to they want to litigate it, and they want to fight that one, and they want to get a solution for it. They want to get some kind of they're expecting some kind of, you know, justice for what has happened to them. Then definitely they will go for arbitration, or maybe, you know, litigation. But they can go for combinations. It's okay, you know. It depends. When they are wise enough, they'll tell, I don't want any of this. I want to be very peaceful. I will go for mediation and I will settle it that and there.
Ma'am, can you give us one example of a cross-border dispute in which you were appointed as an arbitrator, and what are the challenges which you have faced? Any live scenario example which you can give us on a cross-border dispute?
See, thing is, I am currently a part of a few, and as a counsel, it is onus on me to not to reveal certain things. But someday in future, yes, if things are working out well, definitely I will. So I'm sorry, I cannot disclose certain things. We have a contract of confidentiality, so I cannot tell it right now. But definitely, yes, in future, if they are willing to, I can give you an example.
Ma'am, what are the cases in which people can opt for arbitration, and what are the cases wherein people can opt for mediation? Are there any set of specific rules that these cases only have to be referred for arbitration and these cases should only go for mediation? Or any case can go for mediation and any case can come for arbitration? It is like that.
See, for cases which are criminal in nature, definitely you have to go to the courts. But
Correct.
apart from that, if they are contractual in nature and you have an arbitration clause where where a particular person's business has been affected to a great level, where they need some kind of justice, definitely they will go for, they will invoke arbitration. Where they want confidentiality, but they don't want to take it for a longer time, they will go for arbitrations. Where they can enforce the award, they can easily enforce the award and seek some kind of remedy. I don't say justice, seek some kind of remedy in monetary or any other ways. Definitely, they'll go for arbitration. Mediation is more of a process where it's less formal, and where parties are wise enough telling that I don't want to invoke. See, not every case again you can go for arbitration. Not every small business person cannot invoke arbitration. So it's better that they take up mediation, which is effective, and your confidentiality is there, and speedy. It suggests speedy resolution of your dispute, and it's not very heavy. It's not very tight on your pocket.
One last question, ma'am. So, what factors should any business consider when they are selecting a mediator so that it ensures that they are impartial and expertise in their industry? So, is there any specific factors which any business should consider while selecting any mediator, or they can pick anybody they like without expertise in their specific industry?
See, for a mediator, knowledge of the process is very important, and for that, as per the law mandates, they have to be certified for 40 hours for sure. And the mediator should be empathetic and unbiased. These are certain qualities which the mediator will be owning as and when they complete their course, and as and when they start taking up mediation sessions. But sometimes people just pick a mediator, a qualified mediator randomly, and the person might be biased. But the process is so beautiful that as a mediator you cannot be biased. You cannot be biased to one party, and you will be. And one more thing, the mediator should not be a blabbermouth where he or she just blabbers about every party that comes, because when mediation is involved, a lot of sensitivity is required by the mediator, for the mediator. So while choosing a mediator, it is always better to find a person who is empathetic, who is trustworthy, and who doesn't really speak much about you. He or she shouldn't be a blabbermouth.
Thank you, ma'am. Now we are open for questions. And if anybody has any questions to ask, they can switch off, turn on their mic and ask their questions.
Good evening, ma'am. This is Mohammed Asagir from Dr. B. R. Ambedkar Law College. Ma'am, I
Good
have a
evening.
doubt. Like, if a case is going on in a civil court, especially a civil matter, and both the parties, like, after 2 to 3 years of the case, submission into the court, they meet each other and decided to uh, uh, what complete the case. Like, they are eh, deciding to complete the case, and if they are willing to do such, if they can do arbitrate. Like, they can do, they can eligible for the arbitration if the case is going on in court.
Yes.
Is the court give permission to them?
Yes. Very
Okay.
much.
All right, ma'am. Thank you, ma'am.
I think we have another question. Kirtika, you can unmute and ask the question.
Hi, ma'am. Nice to meet you again, ma'am.
Hello, Kirtika.
Yes, ma'am. I had a doubt like nowadays the online mediation is more efficient. So I had a doubt like how the online mediation is more efficient than the direct mediation. Do you think which is more efficient, ma'am?
As a mediator, I would definitely say that it takes extra skills for one to resolve the dispute through online sources also. It is up to how well the mediator can personally connect, how the mediator is personally connecting with each of the parties and is resolving. See, sometimes what happens is in certain cross-border mediations, what happens is the mediator is in some other country, parties are in two different countries, but somehow it happens, especially during COVID, we were part of a few international mediations where the not just during COVID, even after that also we were counsels of a few mediations, cross-border mediations, or even regular mediations which were conducted online. So it was the mediator's duty. It was upon the mediator on how well they connected personally also, and then conducted the session online. But nothing like having a personal touch, nothing like having to meet the parties in person and help them resolve their dispute.
Thank you, ma'am.
You're welcome. Any more questions?
Does anybody have any other question? Yes, Gauri, you can please unmute yourself.
Hi, ma'am. Very good evening, all of you.
Good evening.
Very useful to attend the session, ma'am. I have added one question for, and if nowadays going on family issues for the family courts, recently the Chennai High Court also not appear in the both parties for the physical court. We also obtain the online. Say through connected with the arbitration and mediation conciliation easy to online, ma'am. It's impossible to efficiency, ma'am.
See, online arbitration, see, all these procedures are available online also. We have a lot of platforms coming up with this, but especially see for family disputes, again, it is on the ability of the arbitrator or mediator or the dispute resolution professional on how well they conduct the session online also. So if there is proper support from the platforms, nothing like that. So it's both are efficient, but it's on the, and again, it depends on the parties on how well they accept it. Not just the professional, but also it is on the parties on how well they are able to connect with the arbitrator or mediator, conciliator, whatever you call it, and how well they are able to express themselves. So both are equally efficient is what I feel.
Okay, ma'am. Then another question is, what are the situations so most the parties or any problems of the parties enter to the arbitrations, ma'am, nowadays?
See, mostly disputes which are contractual in nature, they go into arbitration. Many, not just company issues, not just commercial issues, but also certain contractual issues pertaining to your employability and your Section 27 of the Contract Act, where a person has signed a bond with the company and they're not able to come out, or they had to pay something, or the company, the person left and the company is at loss. So at those situations also, there have been conditions where arbitration has been invoked. Any more questions? I think I'll take one last question or.
Okay, thank you, ma'am.
Any more questions are there?
Do you have any questions, Gauri and Kirtika? You've raised your hands.
Yes, ma'am. I had another doubt. Like, in this era, also, if there is any family disputes, the parties only think about the family court and all, not think about the mediation. So, if there any thing is how to reach the mediation to the people like more efficient than a family court.
See, for divorces or partition suits or any family dispute, initially you can invoke mediation. You can create awareness as to asking the parties to settle first, settle the dispute first through mediation, and then go for a divorce or go for guardianship suits. Anything, maybe, for partition, you don't even have to go for a suit, you can just sit together, discuss it, and then go ahead where you don't have to go. But maybe you can enforce the agreement in the court and get the partition done. So awareness in the sense, see, in order to get a divorce legally, you have to go to a court. But at least for mutually settling the dispute, you can enter into a settlement and then go ahead with it.
Yes, ma'am. Thank you.
Yeah. Gauri, you have another question?
Yes, ma'am.
Yes.
Sometimes the both parties enter to the contract, ma'am. Some issues going on. So also putting the civil case also, same the contract issues. When the civil court is possible to sort out the issues shortly, or the arbitration, ma'am. Which one is very effective and periodically get the relief for the both parties, ma'am?
Okay. In certain times where contracts are involved, usually they go to the commercial court for resolving the dispute, and as per Commercial Courts Act or as per Arbitration and Conciliation Act, you can resolve the dispute within 1 year's time. You have to, and if it is arbitration, you have to resolve it within 1 year's time. If not, then it's of no use to invoke. See, sometimes what happens is you can go for litigation, you can file a suit, and then you can say that, okay, we want to go for arbitration because this is time consuming. So it depends. Again, it depends on the councils and the parties as to how fast they want. So you can choose. It's in your hands. Another question? I think it's almost 8, right?
Yes, ma'am. We are almost done with the webinar. Any other questions are there from anyone? If there are no questions, then we'll just wind up with the webinar. So, thank you very much, ma'am, for joining us today. It was a pleasure having you.
Thanks. Thank you for this opportunity.
Yeah, thank you, ma'am.
Thank
Yes,
you, ma'am.
Dastagir, anything? Yeah.
No,
Thank
I'm
you,
just
ma'am.
saying thank you to ma'am for giving such a good knowledge about arbitration and mediation.
Thank you, ma'am. It was very informative.
Thank you so much for this opportunity, and thanks for
Thank you,
attending.
ma'am. Thank you, ma'am. Yeah.
Thank you, ma'am.
Thank you.
You're welcome. Okay.
Thank you, ma'am.
So,
Thank you so much
have
for
a good
giving
night,
the-
everybody.
Thank you so much, ma'am.
Yeah.
You're
Good
welcome.
night.
Good night, everybody. Yes.
Good night.
Good night.
Thank you,
Good
ma'am.
night. You're welcome.
Yeah, ma'am. We'll do that editing.